Hello, everyone, and welcome to Uncivil Law. I hope you are having a very good day today. And we are going to try to do something that's going to be a little bit longer than our normal stream. We are here with the decision in Jane Doe 1 through 22 versus girlsdoporn.com, a business organization et al. This was decided today in the Superior Court of the State of California, County of San Diego, Central Division. This has been filed, I think, for like 2 years. The trial started on August the 19th, and it wrapped up, I think, late November, and the decision came down today. It was a decision by a judge, as I understand it. And so we are going to read the judge's decision. No jury. So we're going to read the judge's decision. Very exciting. And it's 187 pages long. That isn't a misstatement. 187 pages long. I am going to attempt to read this to you with explanation and remain alert and interesting the entire time. Let's see if I can succeed. Very exciting. For those of you who thought to themselves, I just can't get enough Blackleaf, let's find out. So as I say, this is the Superior Court of the State of California, County of San Diego, Central Division, Jane Doe 1 through 22, inclusive, and girlsdoporn.com. All right. Having considered the pleadings, evidence presented, and arguments of counsel, and having assessed the credibility of the witnesses, the court now submits this proposed statement of decision. This is an action for fraud, concealment, false promise, misappropriation of likeness, both statutory and common law, and violation of business and professional codes brought by Jane Doe's 1 through 22 against defendant girlsdoporn.com et al. Jane Doe was represented by some people. Defendant Girls Do Porn was represented by some people. And some other people were also represented by some other people. Defendants run an online pornography business, including, most notably, a subscription website called girlsdoporn.com. The site features sex videos of young women between the ages of 18 and 23. Defendants' business is premised on the construct that women in the videos are not professional porn stars, but are amateur college-age women filming pornography for the first and only time. Subscribers are meant to be left with the impression that the women in defendants' videos are everyday women that they could encounter in their communities, campuses, and daily lives. Defendants are aware the models recruited for girlsdoporn.com do not intend to pursue a career in adult entertainment. The women are mostly students with careers ahead of them who have only considered defendants' solicitations to film a pornographic video due to some immediate and pressing financial need. In accordance with the one-time only amateur paradigm, defendants' business is dependent on recruiting a constant stream of new models in order to generate fresh website content. The court finds plaintiffs have proven that defendants use fraudulent practices to facilitate such recruitment. Defendants take considerable, calculated steps to falsely assure prospective models that the videos will never be posted online, come to light in the United States, or be seen by anyone who might know them. Defendants' assurances of privacy and security are reinforced by paid references, women hired who are or pose as previous models, and in accordance with the script, provide new recruits with false comfort that this experience is safe and enjoyable, and the videos have never appeared online or been discussed by anyone in the models' lives. Once a newly recruited woman has flown to San Diego, she finds herself alone in a hotel room with two men about to shoot a pornographic video. At this point, defendants have her sign documents containing dense and ambiguous legalese, which the defendants falsely describe as being the written version of what she already has agreed to. Defendants rush and pressure the women to sign the documents quickly without reading them, and engage in other deceptive, coercive, and threatening behavior to secure their signatures as described below. The court finds these putative contracts invalid and enforceable, part and parcel of the defendant's fraudulent scheme. Defendant's representations are false. Contrary to the explicit promises, the video will never appear online. Defendants publish the videos on their paid subscription website and many popular free tubes, such as Pornhub.com. They also extensively affiliate, market, and other techniques to maximize web traffic to their sites. Plaintiffs believe defendants increase video viewership of the videos by deliberately leaking and disseminating their true identities and personal information, including by sending the videos directly to the model's friends, family members, classmates, employers, and social media contacts. Nice work. This is similar to direct marketing promotional device that makes the videos go viral in the model's community. When women inevitably learn what defendants have done with their videos, many complain to defendants, begging them to remove the videos from the internet. In response, defendants usually simply ignore such messages and block the complaining model. Very nice touch. Defendants' tactics have caused the videos to become common knowledge in the plaintiffs' communities and among their relations and peers, the very thing plaintiffs feared and defendants expressly assured them would not happen. As a result, plaintiffs have suffered and continue to suffer far-reaching and often tragic consequences. Jake the Hammer says demonetized already. Well, who can we blame on this? It's like, well, we're going to be mentioning a lot of unsafe words, I'm sure. But, we could just tell Google that it's safe for advertisement because all we're doing is discussing the law. That's safe, right? Law's safe, right? As a result, plaintiffs have suffered and continue to suffer far-reaching and often tragic consequences. Consequently, they have experienced severe harassment, emotional and psychological harm, and reputational harm, lost jobs, academic and professional opportunities, and family and personal relationships, and had their lives derailed and uprooted. They have become pariahs in their community. Several plaintiffs have become suicidal. The court finds plaintiffs' injuries are directly attributable to defendants' fraudulent scheme, and defendants' conduct warrants both compensatory and punitive damages, as well as equitable relief. Rename the channel Unsafe Law? I don't think so. I think we're doing fine with Uncivil. Defendants have sought to evade accountability for their actions by funneling the fruits of their enterprise to overseas companies. Defendant Michael Pratt declared bankruptcy. Accordingly, the court determines that each of the defendants are jointly and severally liable to the plaintiffs here and the issues appropriate relief as set forth below. So, jointly and several liability means that everyone is jointly liable for everyone else. So, in getting damages from the defendants, there's a total amount due, and any person who has a right to the money can get the money from any defendant or defendants individually or separately. So if there's a big pocket, you usually get all the money from them, or you can get it from them separately. It's up to you. And then the defendants can sue each other for for compensation to each other for equal distribution of the money, but the plaintiffs don't have to do it in the first instance. So you get the money from anyone who happens to have it. William Blair says, what did the girls think was going to happen and why they get involved? That's a good question, William. We're going to learn more. And don't worry, we have so much more content. We're merely on page 5 of 187. So we've got so much time to discuss so many things. We're going to learn many more things. The websites. Girls Do Porn is a pornographic website featuring young women ages 18 to 23 engaging in intercourse with a male actor. GDP's female models have never appeared in a pornographic video before, and they will not do so again. GDP publishes exclusive content featuring young female models who cannot be seen elsewhere. Example at 1576.1. And there is a citation which we will read. Girls Do Porn channel on Pornhub advertising. Real amateur girls having sex on video for the very first time. You will not find these girls on any other website. All girls are 100% exclusive. This is the only and only time they do porn. This is the only and only time. Who wrote your copy, ma'am? Defendants recruit the women, produce the videos, and solely control the content that appears on girlsdoporn.com. And it's undisputed that the pornographic videos and photographs of all the plaintiffs were published on girlsdoporn.com. Girls Do Porn earns money by selling subscriptions to view the complete video content in the members only section. As set forth below, the court finds the defendants own or control the rights to girlsdoporn.com content, trademark, and domain name. Girls Do Toys is a pornographic website featuring young women in solo scenes. The women are usually the same as shoot the girl-boy videos because defendants do not separately recruit women for the solo videos. Defendants shoot, produce, and edit the videos for Girls Do Toys, and the website earns money through subscription sales. Defendant controls all aspects of the website. As explained below, the court finds defendants own or control the rights to the trademark, domain name, as well as content on the site. Mom POV, that's great, is a website featuring mature women over 30. Okay, we'll just skip that. Defendant Michael Pratt, originally from New Zealand, conceived, interesting word choice in an article involving sex and pornography, but okay, conceived the idea for Girls Do Porn in 2006 while he was living in Brisbane, Australia. He moved to the United States in 2007 and launched the website in 2009. He has owned and operated Girls Do Porn through a series of different entities throughout the years, but has always maintained ultimate control of the website, as well as those individuals he hires to assist him in producing videos for his websites. Pratt recruits models and has served as a videographer and then edits and publishes the videos himself. Nice. Pratt receives 100% of the profits made by the website. Pratt also founded the website Mom POV with Douglas Winterhold in 2010 and the website Girls Do Toys with Matthew Wolf in 2014. Pratt was involved in the recruitment of and served as videographer of Jane Doe's 3, 4, 5, 9, 11, 13, 14, 15, 18, 19, 20, and 22. Very exciting. As videographer, Pratt also presented documents to models to sign and answer any questions they had during the shoot. Douglas Winterhold, not a defendant, was hired by Pratt to serve as a male performer. Nice. Lucky him, I guess. In 2010, he and Pratt founded the Mom site. Winterhold also served as the male performer in Mom POV videos and generally handled operations of that website since its inception. He stopped shooting videos for Girls Do Porn in around 2012. Winterhold did not interact personally with any of the plaintiffs. Defendant Michael Wolf, a childhood friend of Pratt from New Zealand, joined Pratt in the United States and began producing services for Pratt's pornographic business in 2011. Wolf's duties include or have included payroll, bookkeeping, billing, technical assistance, recruiting, and videography. As a videographer, he often answered questions posed by models and presented documents for them to sign. In 2011, Wolf and Pratt purchased the domain Girls Do Toys, and Wolf has filmed many of the videos. He was produced as the PMQ. What is PMQ? Other than Prime Minister's Questions, which I'm assuming is not what this stands for. What is PMQ? Okay. He was produced as the PMQ for the entities that run Girls Do Porn and Girls Do Toys in this case. In his testimony, Pratt deferred to Wolf as more knowledgeable on many issues relating to his businesses. Wolf was involved in the recruitment and or served as videographer for Jane Doe's 1, 2, 5, 7, 9, 10, 12, 14, 17, 21, and 22. Defendant Andre Garcia was hired by Pratt to serve as a male talent and casting director. Garcia earned a commission for each model he recruits and is paid hourly rate on top of the commissions. As a male talent, Garcia often presented the documents to models to sign and answered questions they posed. Garcia is the male talent appearing in each of the plaintiff's videos and was involved in the recruitment process or otherwise made representations to Jane Doe's 1, 2, 3, 4, 5, 6, 7, 8, but not 9, 10, 11, 12, 13, 14, but not 15, 16, or 17, 18, 19, 20, and 21. Person most qualified. Thank you for answering my question. So I guess Andre Garcia was the lucky guy who got to have sex with all these girls. So good for him, I suppose. Was it worth it to Garcia? Probably. Theodore Yee worked as a videographer for the websites from November 2015 through April and May of 2017. As part of his job, Yee also assisted with chauffeuring women around San Diego. As part of his job, Yee also served with chauffeuring the women around San Diego and often presented documents to models to sign and answer questions they had. Gee served as the videographer for Jane Doe's 6, 8, 11, 13, 15, 18, 19, and 20. Yeah. Anyone noticed that it's the Does in Jane does spell another word in this instance? The Does spell another word. Well, yeah. Am I reading the whole decision? I'm trying to. That is the working goal. We are on quest to have the longest live stream ever. We're on page 8. So, yeah. We're 5% of the way through. Great. Valerie Moser worked for Pratt as an administrative assistant from March 2015 until 2018. She organized contracts, receipts, and expenses and performed QuickBooks and payroll. Are we doing this instead of oral arguments? We don't have any oral arguments. Not that I'm aware of. This was argued at the state court, and I'm not aware of any audio from that court. If there's audio from the court, I would be happy to do it, but I don't know of it existing. So, yeah, I don't know the arguments. Or unless you're just making a joke on the word oral, in which case still no. In or around 2018, Pratt asked Moser to assist with recruiting certain women BLL Media had been unable to convince to shoot a video. Pratt instructed Moser on what to say and what not to say when recruiting, and Moser took notes. Moser did not personally interact with any of the plaintiffs. Ken Holloway, a now deceased attorney out of Wichita, Kansas, assisted Pratt in forming the first entity that would eventually become the enterprise at issue today. Holloway also incorporated entities in Vanuatu on Pratt's behalf. I don't know where that is. I'm assuming it's some country that, makes this really easy or something. Pratt claims that Holloway owned all the videos produced for the websites by way of these Vanuatu entities, but for reasons stated below, the court finds that Pratt owned and controlled these entities as well as the right to the videos. Yeah. This was demonetized as of 18 minutes ago. Yeah, well, we kind of knew that was coming, right? Because, of the wording that we're using. But why would YouTube object to this? All we're doing is discussing a legal decision, and we're just using the words the court used. So why would they object? We're just discussing law. Gah. Island nation in the South Pacific, duly noted. Reference models. Defendant hired reference models to assist with recruiting by communicating with the prospective models to assuage their objections and doubts about filming a video. Pratt, Wolf, or Garcia instructed the reference models on what to say when they spoke with the models. These reference models who communicated with the plaintiffs in this case include Caitlin Wright, Amberlyn Nord Clark, Alicia McKay, and Kat Wilkins. So I love how we're using real names of the reference models, but the plaintiffs are anonymous. Interesting choice, but okay. Defendant hired other individuals to assist with their business operations, including Alex Bartides, who produced DMCA takedown services for the websites, Alex Foster, who acts as videographer for the websites and other productions, Cameron Brown, who produced DMCA copyright removal services for the company, and Kevin Gibson, who was a producer working alongside Mr. Pratt from at least 2016 until October 2018. Defendant hired Jamia McDonald, Kevin Gibson's then girlfriend, to repeatedly harass plaintiff's counsel with phone calls every day for $300 a week. Wow. The defense hired someone to harass plaintiff's counsel with phone calls. Wow. That's nice. Yeah. None of these individuals personally interacted with the plaintiffs in this case. Pro tip, don't harass opposing counsel. That's a pro tip. Defendants use more than a dozen entities to operate their websites. Defendants admit to owning either directly or indirectly some of the entities, including various things. Defendants deny holding ownership in several other related entities, including various things. In fact, these entities that are, at one time or another, have purported to hold rights to the videos the defendant produced, the domain names of the websites, and the trademark of their brands. The entirety of defendants' assets. Each of these entities exists under the laws of the Republic of Vanuatu, a tiny remote island in the South Pacific. The court received no evidence of writings establishing the Vanuatu entity's separate and independent status. The court received no evidence of consideration paid by defendants to these entities in exchange for ownership rights. In other words, we don't see a sale, between two businesses. Nor do defendants claim that they do not own these entities, but they claim to have no knowledge of the person who does own them. Okay. Taking into account each party's ability to provide evidence, and noting the absence of evidence supporting defendant's theory, the court finds there are no contracts, no consideration, and no third-party entities, owners, known to the defendants because defendants themselves own the entities. In other words, I, the court, do not believe you. I believe you do own these companies in Vanuatu. I heard the evidence. I say you do own them. Excellent. Wonder if Uncivil Law can kill the message holding for this video. I don't know. Why would an organization have to gain from forming in Vanuatu? I don't know. I honestly to God don't know why you would. I assume it's part of like shielding money. I assume it's like because it's hard to get money from them. I assume that's the reason. If we put the money there, it makes it harder to get money out of them. That'd be my base assumption. Nate Brody. Nate, how are you doing, brother? Man, I am so happy to hear from you. I'm glad to see you have internet access again. And, as always, would you like to join me on stream discussing this case? We could discuss it together. My working plan was to read the entire complaint and explain it, the entire decision and explain it. Really, we're on page 10 of 187. My working plan is to read this and explain 187 pages. So we're going for marathon session today. Good times. Let's see how long I last. Har, 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 har. Over the course of a 99-day trial, that's a long-ass trial too, the court heard from 22 plaintiffs, live and by deposition, who provided credible testimony. The court also heard from several non-plaintiff models who testified about one of the most humiliating and devastating experiences of their young life. I'm doing fine on the water. I came prepared, man. Yeah. Plaintiffs further called 4 women defendants hired as reference models. These women admitted to lying to prospective models, such as the plaintiffs. Yeah, right, Nate? Nate, I mean, a 99-day trial is like longer than pretty much any trial I've ever heard of. I mean, that's a long-ass trial, 99 days. Jesus Christ, what were they talking about? These witnesses admitted to lying to prospective models, such as plaintiffs in this action, even though by telling the truth, they implicate themselves in a fraudulent scheme. You had 50 people testify? I guess that's a fair point. But still, that's a lot of time. Finally, plaintiffs called 4 defendant employees who, in testimony, in part corroborated that of the defendants. Yeah, they did say they heard from 22 plaintiffs, and they heard from 7 non-plaintiff models. So that's 29, and then some other people. So I'm not sure how many people testified, but at least 29. At this rate, we should only be here for about 7.5 hours. Excellent. The success of defendants' business turns out on their ability to induce young women who would not otherwise consider filming videos to fly to San Diego and shoot a pornographic video. And by the way, Nate, I still do want to do something together. So, unless you're ignoring me, in which case I understand, I'd like to do something with you. So I hope you're not ignoring me. I hope I didn't offend you, man. Defendant success in doing this is based on several practices. First, they drew women in through bait and switch advertisements for clothed modeling. Second, they offered enough money to overcome the woman's general compunction against the idea. And third, they lied about the significant concern women have, where and how video will be distributed and who will be able to see it. Finally, by carefully concealing their own identities at every stage of the recruiting process, defendants severely curtailed the women's ability to investigate the truth of these misrepresentations, concealment, and to protect themselves against defendants' fraudulent scheme. If only I knew their names, then we could review the videos as well. Merely for legal purposes, of course. I'm sure YouTube would love that, if we had it, because it's evidence in the case, one would presume, right? So, if I knew what they were, if I knew their names, we could discuss the evidence, we could view it shot by shot, discuss the legal implications. YouTube would really, really like that, wouldn't it? Oh man, geez, good times. Defendants post to $5 says, we're going to do something. I got the teen mom story to finish, and then I'm back to law. Excellent, Nate. Thank you. I appreciate that. When I reach out to you and you don't reach back to me, it feels like I'm being deliberately ignored. It makes me sad. I'm like, oh, am I being deliberately ignored? Oh. So I'm glad to know that's not true. Defendants post advertisement on Craigslist that purport to seek women from clothed modeling work in towns and cities all over the United States and Canada. These facially benign ads offer to pay women ages 18 to 22 with little to no modeling experience a large sum of money, typically $5,000, for photo and or video shoots. Personally, I think that might have been a clue, but okay. The ads also direct prospective models to defendant-owning modeling websites, such as various websites, which also appear to advertise clothed modeling work. The websites contain application form where models can enter their names, ages, height, weight, locations, and contact information and attach photographs. Neither the Craigslist ads nor the websites contain any information that nudity or pornography is involved. Contrary to defense explanation, the court finds defendants deliberately used deceptive advertisements and mislead women about the nature of the work. Defendants aim to cast a wider net to attract certain type of women who would not initially respond to a solicitation to appear in this type of video. This is consistent with defendants' depiction of GDP models and making a one-time only stint into pornography. Women can apply for purported modeling work through Craigslist by email and providing information. Defendants use a few different stock emails to respond to applicants, but once the received by the plaintiff is a stock email from Jonathan. This email does not use the word pornography, but instead states this is a legitimate adult gig for established Southern California company. Nice. This stock email makes the gig sound fast, easy, and safe, and begins assuaging the women's concern right off the bat. None of your personal information will be given out in the video or afterwards. No names are used in the video. The email also represents we have shot over 200 plus models. You can speak to or Skype with as many as you want and talk to them about their experiences with us. In reality, although defendants have shot hundreds of models, they only permit a prospective model to speak with a few select references, some of whom are not actual models, but have been hired to give fraudulent testimonies. In any case, defendant channel new recruits solely to particular references who have been instructed and paid to give a false narrative. Although some plaintiffs respond to the first email, each plaintiff testified that the idea of filming a pornographic video triggered concerns about where the video would be distributed and who would be able to see it. Plaintiffs were all aware of the existence and proliferation of internet pornography, which, makes you wonder what representations could possibly be given that would assuage those concerns. I mean, what representations could you possibly make to assure someone it would never show up on the internet, right? But okay. But they wanted to hear more about this particular because the email indicated their identities would be protected and suggested that other women who shot a video did not regret it. Even if that were true, the internet lasts forever, so, This job also offered notably high pay for what appeared to be very little work, again, which may be a clue. Plaintiffs testified that although ordinarily they did not consider doing this offer was uniquely enticing. If women do not respond to the initial email, defendants do not give up. Instead, they send a follow-up email, sometimes increasing the amount of pay and offering clothes modeling and more detailed assurances. Some plaintiffs respond to this email specifically because of the offer to do clothes modeling. In fact, clothes modeling has never been part of defendants' business. The court finds defendants made this offer with no plan or intention to fulfill it and included in the email solely for the purpose of misleading women about the nature of the job in order to elicit a response from those who would not otherwise respond. Several plaintiffs testified about the second email they found particularly persuasive. It provides more details about the types of girls who have done a shoot. All the girls I shoot are first timers. I shoot cheerleaders, sorority girls, preppy college girls, Instagram models with 70K followers, and models of that caliber. Several plaintiffs testified that these representations helped to lure them in because the type of girl described were relatable to them. Jane Doe 15 was on her collegiate cheerleading team. Jane Doe 13 was in a sorority. Plaintiff also interpreted this statement to mean that the women who led similar lives to their own had not been negatively impacted by shooting the videos and continued to live normal lives. I mean, again, at least to me, it's like, I mean, even if every word of that were true, it's like video lasts forever. The internet lasts forever. How could you possibly be assured it wouldn't get out? It's like, even if every word of that's true, and even if none of them had thought to, regret it up to that point, still, to me, it's like, I don't know. Especially when you're aware of the spread of internet pornography, as they all said they were at the time. So it's like, this content in particular is probably going to get out. I mean, just saying. The follow-up email also states we have 50 models you can speak or FaceTime with. Defendants even sent pictures of recent models who looked like ordinary women who were happy and safe. Many plaintiffs testified these pictures were relatable and made them feel comfortable. Defendants also sent pictures of hotel rooms, the sets, camera equipment, and the performers, which plaintiffs testified improved their comfort level because they felt defendants were being open and generous with that information and because the images looked professional and legitimate. It should be noted, defendants also present the experience as a glamorous opportunity to travel to Southern California and enjoy immense amenities they could not ordinarily afford. One indicated this deception influenced her decision to respond to the ad, noting it sounded like fun to be treated like a celebrity for a day. Well, I think you actually got that part of the bargain. I know how a lot of these celebrities are really treated sometimes, and the life behind the camera can be much less glamorous than on, is my point. Other plaintiffs testified these representations assisted in convincing them. Defendants ran a legitimate professional operation. The court also finds defendants' business strategy to offer as much money as needed to entice to recruit for a shoot, but sometimes with no intention of actually following through. This often increasing the officers until the candidate agreed. For example, Valerie Moser testified that Pratt instructed her to make an offer of a price that was high enough to get the model on the plane. Defendants used this strategy with multiple plaintiffs. Jane Doe in 6 in particular did not respond to the email until he increased the offer from 5 to 2 videos to 7 for 1 video. She testified she would not have agreed to anything less. At this moment, I am reminded of a famous Winston Churchill quote: "We're no longer debating what you are, we're merely negotiating over the price." Outstanding. Defendants sometimes do not honor their promises regarding pay. Once a model has arrived at a hotel room in San Diego and is stripped down, defendant at times used a pretext, a supposed flaw in her appearance, to pay her less than the agreed upon amount. Defendant never previously informed the model that her pay is not fixed but contingent and subject to change. Some plaintiffs would not agree to the videos had they known defendants claimed unilateral decision to slash their pay, often by thousands of dollars. However, by the time the models arrived in San Diego and filming is about to begin, they have no choice to relent and proceed with the shoot. Defendants threaten them with consequences if they do not do so. The court finds defendant deliberately misled some models by increasing or overstating the amount of pay with little intention to fulfill the promise. That's pretty scummy. Defendant's goal is to initiate a phone call with a prospective model as quickly as possible. When a model asks a question by email or text, defendant answers some questions in writing, but if a prospective model asks about where the video will be distributed, defendant always asks to discuss it over the phone, which they didn't want anything in writing. Good for their scheme, by the way. It's like, we don't want that part in writing. So, yeah. The court finds defendants deliberately avoided written communications about distribution with prospective models because defendant misrepresented where and how the videos will be distributed. Defendants produced no written communication to the contrary. Based on constant testimony at trial, the court finds during the initial phone call between defendant and prospective models, defendants assure the women that the video will never be seen by anyone they know because it will only be distributed in DVD in foreign country. I mean, again, they're aware the internet exists. They said so under oath at the time. So, really? It's on DVD, so just saying. While the details of the defendant's representation vary slightly, the part of the message that mattered to the prospective models remain the same. It's not going online, and no one in the United States will find out. Yeah. The specific destination represents simply made these material representatives claim credible and believable to plaintiffs. So if I understand the court's decision so far, if I understand what I'm reading so far, the producers of these videos made initial ads that did not mention the nature of the videos. At some time prior to them coming out to California, the nature of the videos was revealed. If I'm understanding them correctly, they're not saying that any point prior, they're not saying like they didn't know about the nature of the videos prior to them coming to California, if I'm understanding it correctly. So they discussed it at least on the phone. So they all of them knew for a certainty, as I understand the facts relayed by the court, and this is the court's decision, so I can say for a fact, because the court just made facts, right? So as I understand, every girl knew for a fact what the nature of the videos were before they got on a plane. And they also knew about the internet, and they knew about the desire for this kind of material. It's like, how could you possibly think it wouldn't stay offline forever? And you were willing to engage in this conduct for money. So, just saying that if people have a negative view of that, well, you're aware of that, which is one of the reasons you didn't want to get out. And so, you knew you're putting your reputation on the line, possibly forever, because video never dies. So, I'm just saying. Jan Negri says, Blackleaf, just because at worst some of these ladies are stupid or rather naive, it still doesn't mean it's okay. I'm not arguing it's okay. I'm pointing out. It's not really about me blaming the victim, right? I can think two things at the same time, or at least I believe I can. I can think that the producers, engaged in fraudulent misrepresentation. And that fraudulent misrepresentation is a fraud in the inducement, to use the legal language. So there's fraud in fact, where the actual material of the contract is fraudulent, and there's fraud in the inducement, where I am inducing you into the contract, but the contract is true. And so I can believe that there was fraud in the inducement, which the court seems to be finding. And fraud in the inducement would be valid grounds to terminate the contract and set it aside. So I can believe that, and simultaneously believe that the women were behaving in a way that was, there's some responsibility, for things, because there was plenty of warning signs, and they knew what the material was, and they're aware of the internet, and they're aware of the desire for this material, and they knew like this content gets distributed. So I'm like, I'm just, for me to believe that they're liable is not for me to believe that the victims are blameless. You could have blameless victims, but there's blame to go around. It doesn't go to the ultimate issue of liability. But if you can't look at this, or at least for me, it's like, if I can't look at this and try to be like objective about who is responsible for what and to what degree, it's like, as I'm trying to appreciate this and trying to analyze this, it's like, what am I doing here? We see cases all the time where the defendants are completely blameless, and we see ones where they're to blame to some degree. Doesn't mean that they shouldn't recover, but we wouldn't be honest if we didn't say, well, here's a whole bunch of things that go against your argument, right? These are factors that we can consider in the ultimate conclusions we're trying to reach. So, that's kind of what I'm thinking. So I don't know if any of that makes sense, or if you hate me as a result of it. I'm just trying to be objective. Who did what, who knew what and when, what amount of responsibility can we put on who? These are the kind of things that I'm trying to weigh as I read it. Yeah. So on civil law, if you want the audio, it's $28, but I can't get it yet. Well, presumably that would be the audio per day, right? I'm just guessing, Matthew. It's not $28 total. Probably. If it's $28 total, I'll be thrilled. If I have to pay $28 per day, if I have to pay $3,000 for the audio, I'll be less thrilled. But at least I could get the arguments, I guess, at the end. But yeah, I might spring for that. Yeah, looks like I have to go to the courthouse. I can do it by mail. I looked into this, by the way. I looked into it already. I can do it by mail. So, yeah. Every plaintiff and by the way, if you disagree with me and you think like I'm being a jerk, or I'm being unreasonable, or like I shouldn't be asking these questions, or whatever, I don't mind people disagreeing with me. I would appreciate it if you not call me names while you're disagreeing with me. You can say Blackleaf, that doesn't make sense. Blackleaf, I disagree. Blackleaf, whatever. Then we can have a discussion. I'm giving you my perspective. I don't mind if you disagree with me. So if you think that me saying, well, here's what the women apparently knew, here's when they knew it, here's the knowledge, and so therefore I see that there's some fault there. If you think that that's a wrong decision to make, or wrong analysis, or I shouldn't be asking that question, leave me a comment. I engage with you. So, I'm just saying, if you think I'm wrong, tell me I'm wrong and why. And we'll have a discussion about it, and maybe you'll convince me. I like telling you what I think, because I might be stupid. And if you tell me, hey, Kurt, you're being stupid, then there's a possibility I'll be less stupid. And that's always a plus, right? I can learn things. Every plaintiff's significant concern was where the video would be distributed and who would see it. Nearly every plaintiff asked questions and expressed concerns about distribution during the phone calls with defendant. Some plaintiffs testified they did not have a chance or need to ask questions because defendant told them what they wanted to know as soon as it got on the phone. Some explained their particular situations and reasons they were concerned about distribution of the video. Defendants assured each woman that they had done this many times before, and the videos had never appeared online, and no one in the United States had ever found it. Is there a 2257 form? I mean, presumably. Hello, Andy. How are you doing? Presumably there is, as part of the agreements they're signing. One would presume. That's for like representing the models over 18, by the way, is what he's referring to. Yes, some blame is to them. No, I don't hate you. I just warn that someone who doesn't know you might get the feeling you're victim blaming. I mean, in law, yeah, I appreciate what you're saying. First of all, let me say I appreciate what you're saying. But in law, and I like to play the role of the judge. I'm judging the judge's decision. I'm using what they're saying and I'm going through my own analysis. And so one of the things as in law we have to do, especially in a civil case, because different states handle this issue differently, by the way. And if memory serves correctly, California is a is a strict comparative liability state. So if there's X amount of damages and you, the defendant, are responsible for 1% of that happening, then as I remember California law, and I could be mistaken, this is in tort, by the way, not contract, because the issue here is the contract is void. So that this analysis doesn't apply. This would be in tort. But if you were 1% responsible, then the amount gets reduced by 1%. So you only get 99%. So the amount the victim is to blame is relevant in California because it directly goes to the percentage of the amount given to you. It's even more relevant in my former home state of Virginia because in tort, if the defendant is 1% responsible, the defendant collects nothing, zero. They have a contributory negligence instead of comparative negligence. So Virginia and Maryland and DC say, if there's amount of damage that is damaged to you, if you are damaged $100,000 worth of damage, and the plaintiff is 99% responsible and the defendant is 1% responsible, the amount the defendant collects is zero. I'm just telling you what the law is. So understanding how much the plaintiff and defendants are individually liable is very relevant to our legal determinations sometimes. Just saying. So, yeah. An Evil Tribble says, I have a bone to pick with the victim blaming slur. I didn't interpret it as a slur. I understood the intent behind the statement. I understood what she was meaning. She wasn't saying I was victim blaming. She said other people might interpret what I'm saying as victim blaming. Other people might use that slur against me. And, other people might. And so I'm trying to explain what I'm trying to do and why. I'm acting as a judge. A judge and the law is supposed to be very dispassionate. Remember, blindfold on? Remember the whole blindfold and scales? Right? We're supposed to be blind. So I'm not supposed to worry about issues like that. I'm not supposed to worry about it. I'm just supposed to weigh the scales. And the defendant's conduct might be relevant to the scales. Because I'm blind. I don't care about who they are. I don't care about their young women. I don't care if they're old men. I don't care about everyone's equal before the law. And so I'm trying to assess the responsibility of everyone because I'm blind to that and just judging it on the merits. Like a good judge, hopefully. Nor was there any particular act of diligence that would have revealed the truth to plaintiffs and other women ensnared in defendant's scheme. Defendants' use of aliases or other businesses' names and websites ensured a prospective model who checked defendants' reputation on the internet would not learn they owned and operated a popular website called Girls Do Porn, and that the videos were strewn among dozens of other websites. Yeah. So that would qualify as fraud in the inducement, right? You didn't know at some points, and then you lured them into a false sense of security, and then you revealed some things. And so it's basically a little bit drip kind of philosophy. So fraud in the inducement, sure, I can understand that. Defendant argued the plaintiffs did not do their due diligence because they did not obtain an explanation for how defendants could guarantee the video would not be uploaded. Well, that is, I have to give defendants that point. How is that possibly true would be a question that would come to my mind. However, defendants' scheme were remarkably successful for a reason, and the sheer number of models, numbering in the hundreds, attest to its effectiveness. Plaintiffs were young individuals with no experience in this industry. Defendants, on the other hand, were significantly older and held themselves out as experienced professionals with knowledge of how the videos would actually be distributed and who would actually have access to them. Plaintiffs asked defendants extensive questions regarding their concerns, and defendants provide answers that placated those concerns, and to a person of plaintiff's age and experience, it seemed quite reasonable. Plaintiffs have no ability to independently verify the information defendants provided, and for little reason to do so. The record established plaintiff relied upon the assurances as defendant knew and hoped they would. So they tried to induce, they were in fact induced, basically. That's the court just said in so many words, the plaintiffs attempted to fraudulently induce, and they were in fact induced. So there was fraud in the inducement. Okay, great. Andy says that the producers are gray listed, work at own risk, which means they were considered a danger. Nice. What does it take to get blacklisted just out of sheer curiosity? Or is that even possible? Yeah. He, by the way, apologize, Jan. Apologize. Apologize, Jan. I understand and accept how many percent of the blame is that's cool, but if you have some small part of the blame and you're treated as negligent, no. I agree with you. I don't agree the rule is good in Virginia. I agree with you that, like, if you're 1% responsible and you can't recover, that doesn't make sense to me. I'm just telling you what the law is. I disagree with the rule, but that's the rule. So, you know. Defendants affirmatively stated in no uncertain terms that they would not distribute the videos on the internet, but would target them exclusively for very limited DVD production in overseas locales. They then proceeded to do the exact opposite, guarantee the videos would be widely published on the internet and disseminated in plaintiffs' communities. What might have conceivably transpired if the videos had instead been sold to a single private collector in Australia, for instance, is beside the point. I'm not sure it's completely beside the point. I don't know that I agree with the court there, because one of the things a court can consider is the counterfactual, right? Like, what would have happened if, and like compare that to that reality. So I'm not sure I go so far as to say it's beside the point. You know, but you know, it's a small quibble. It's a small quibble. Defendants are persistent in their recruiting efforts. Several plaintiffs testified defendant called and texted them multiple times a day. You could have blocked them, just saying. Jane Doe 20, for example, agreed to do the shoot and booked the flight, then got cold feet and backed out. She testified that Pratt called and texted her, comforted and convinced her until she finally relented. Defendant also used other means of communication to convince women to trust and believe them. Defendant offered to FaceTime or Skype with women while they were at another shoot to show them around set. Nice. Which also, like, by the way, just saying, okay, you are offering to FaceTime or Skype with another woman who is being shot. So, like, again, this might be an indication that only this private collector will see them. May not be wholly representative of reality, because you're seeing it, and maybe someday will see you on this Skype. So, you know, just saying. Several plaintiffs testified that communication made them more comfortable and increased their trust in defendants. Jane Doe 6 testified the photos defendants sent of money, previous miles, and hotel rooms looked like everything was promising. Very good. And Matthew points out there is, in fact, a third rule here. He is correct. There is a third rule where, because the 50% threshold. So in California, as I understand it, if my memory serves correctly, if the plaintiff is 1% responsible and the defendant is 99% responsible, you still get 1% of the money, I think, because they have a what we might call strict contributory liability statute. So the plaintiff is responsible for as much as the plaintiff is responsible for. So there's $100,000 in damages and the plaintiff is responsible for 1%. You still get 1% in California, I think. And if memory serves correctly, and it's been a long time, I think they're the only state with that rule. Most other states, so California is the you still get 1% rule. Virginia, Maryland, and DC are the if your defendant's 1% responsible, you get nothing. And then Matthew points out the other rule, which is the rule in 46 other states, as far as I remember, that as long as the defendant is not more than 50% responsible, the defendant collects pro rata. So again, if it's 1% responsible, it's 1% reduced. But in most states, if the defendant is 51% responsible, you get nothing. California doesn't follow that rule. They give you as much as you're entitled to. But most states, Matthew is absolutely correct. Most states have a 50% cutoff. But, you know, Virginia is mean and says 1% is our cutoff. So, okay. California is pure comparative negligence. Matthew says my memory is right, which is validating because last time I read this rule was, Jesus, it would have been 14 years ago. 14 years ago was the last time I read this rule, and I still remember it. Awesome. My memory is still working. Excellent. Yeah. One of the defendant's most effective recruiting techniques was the use of reference models to speak to prospective models and bolster defendants' misrepresentations. Knowing that their own assurances would only take them so far, defendant hired women to speak with the prospective models. Defendant used three reference type of women. The first type consists of women who have recently shot a video with defendants and have not yet learned the videos are released online. The second type consists of prior models who are in fact aware the videos are published online. The third type consists of women who have never actually shot a video with defendants but are paid to say they have. Reference women from each category testified at trial. Yeah. Emblyn Clark was friends with Andrea Garcia when he asked to reference to him in recruiting the models around 2016. Clark knew Garcia was an actor and recruiter. She never filmed a video with defendants. So she's one of the people that's just hired to say I was and was lying. Clark testified Garcia instructed her to tell prospective models the videos wouldn't be put online and they go to a private collector located outside the U.S. He also instructed her to assure models no one would find out. Clark admitted to it acting as a reference for just a handful of women, and she was compensated based on defendant's attractiveness rating for each woman. Nice touch. Clark acted as a reference for at least two plaintiffs, Jane Doe 6 and 15. Yeah. Livestream California bar exam with no prep. I don't think I would attempt that. You know, my information is California specific rules. California tests a lot more of their state law on the bar exam than most people, so I don't think taking the California bar exam blind is a good idea. I do it just about anywhere else but California. Yeah. Kathleen Wright was an unsuspecting reference at first, but continued to act as a reference even after she learned the truth. I'll tell you what, if I get 1 million subscribers, I'll do the California bar exam with blind. How about that? California bar exam for 1 million subscribers. Let's do that. She testified defendants paid her to talk to potential models and make them feel more comfortable and the like, and reassure them it was fine and legit. Defendants instructed Wright that if a prospective model asked her where the videos would go, to tell them it would not be going online and it would be going overseas to wealthier countries. When asked why she told women that their videos would not be released online, she knew that when this is not true because that's what they told me to say, that's what they're paying me to say. Jan, who is a guy, apologize, Jan, deciding to have sex based on maliciously false information, to say the least, is iffy. Well, this gives me an opportunity. This gives me an opportunity to talk about the differences as it applies in contract law versus in rape. So you might be wanting to know, why doesn't this qualify as rape? Well, let me tell you. In contract law, you can have two different kinds of fraud, as I mentioned before. Fraud in the inducement or fraud in fact. So fraud in the inducement is I'm tricking you into the contract. Fraud in fact is the contract is not what it purports to be. You know, there are things other than what it purports to in fact be. And fraud in the inducement is not, to the best of my knowledge, and there may be an exception somewhere on this, but to the best of my knowledge, fraud in the inducement does not qualify as rape, but fraud in fact does. So that is the distinguishment on that law. And the reason for that should be reasonably obvious, because people tell lies to each other quite a lot when they are courting each other at bars, for example. And if fraud in the inducement, for example, saying like, I'm a doctor when I'm not a doctor, or saying, you know, I'm X when I'm not X, if saying that qualified, then like rape would be happening all the time, right? So like the law says, no. People lie about sex. Amazing, right? So people lie we are not going to qualify as rape in the inducement, or rape as or fraud in the inducement. However, fraud in fact is. And an example of that would be like if you tricked a woman into thinking you're one person versus another. So, for example, in the movie Revenge of the Nerds, you know, I don't fully know the law that applied at the time and the jurisdiction that they applied, but what he did was he knew for a fact that she was planning to sleep with her boyfriend who'd be wearing a mask, or that, no, he wouldn't be wearing a mask, but he was coming to a particular location at a particular time. So he tricked the boyfriend and then put on a mask and then proceeded to have sex with her. That would qualify as fraud in fact, because she thought she was doing one thing when she was in fact doing another thing. So that would qualify as rape in Revenge of the Nerds. So there is your object lesson using an 80s comedy. How exciting. Wright testified that when she was recruiting models for defendant, she had a text message saved to her phone that she'd send to women. She identified Exhibit 745. Wow. Okay, so that explains why the trial went on 99 days. Exhibit 745, produced by Jane Doe 15. So, like, someone do the math on that. Like, if Jane Doe was Exhibit 745, what exhibit was Jane Doe 21, assuming they were evenly spread? Yeah. Yeah. Taylor Rogers also acted as a reference for previous models, but she did so only prior to learning her video had been posted online. Rogers shot 2 videos with defendant based on Pratt's assurances that he'd absolutely not be online. It was only going to be distributed in Australia to some rich guy. Prior to shooting the video, she received 3 to 4 references from Pratt and spoke to each one. 50 what? That, yeah, I'm not sure what I see there. After she filmed her first video, Pratt and Garcia offered to pay her to speak with prospective models, and she agreed at the time. Oh, 50? Yeah, thank you. 1050? Thank you. Because she believed defendants had told her the truth. Pratt texted her examples of what to say and knew from prior girls they were just trying to make them feel comfortable. As instructed and as she believed to be true, Roger told 5 to 7 women the videos would not be distributed anywhere except to DVD to a guy in Australia. One of the prospective models she spoke to was Jane Doe 12. Rogers shot a second video before learning her first video was online. After she learned the video was online, Rogers was upset that she had encouraged. Sean, don't worry. We're on page 21. How long have we been going? An hour? Well, Jesus, man. I doubt we're going to make it. We're not going to make it. We're on page 21 of 187. Oh, God. Alyssa McKay, another woman who shot the video with defendants based on the same false statement, agreed to be a reference because she believed what they told her about distribution was true. After she learned the video was online, Pratt asked her to continue as a reference. She asked what she was supposed to say when someone asked about distribution. Defendants instructed her she could be evasive and direct the prospective model to Garcia. I'm a lawyer. I am an actual lawyer. I just pretend to be a judge for the purposes of YouTube. So when I say I'm acting as a judge, I'm a judge only on YouTube world, but I am in fact actually a lawyer. If I were actually a judge, me doing this stream would probably be a violation of my ethics. But I haven't studied the judge ethics because I'm not a judge so I don't know, but it probably would. So, just saying. Several plaintiffs testified they are eager to speak to the references, asked pointed questions about distribution, and likely would not have filmed the video if the references not confirmed defendants' representation about distribution. Some plaintiffs stated communicating with the references increased their trust in defendants and solidified their decision to shoot the video. A few plaintiffs were given or offered references but did not contact the references for a variety of reasons, but all stated that just being offered made it seem supported and legitimate. Defendants' method of including women believe their representation about limited scope of distribution had been honed for nearly a decade. Prior to hiring women to cajole prospective models, defendants directed women to a website called bubblegumcasting.com, cute, where they could view testimonials of young women praising their experiences working with defendants. While some plaintiffs required more convincing than others, all plaintiffs ultimately believed the promises about limited distribution. Presumably, yes, they all did, or they wouldn't have done. Yes. Matthew says, for those who care, there are 3,032 documents filed in this case. Well, that is a lot. That is a lot. Now we're beginning to understand a little bit more about why the trial lasted 99 days. Man, that's a lot. That's a lot for an attorney to keep in check. Man, geez. I mean, you have to like second, third chair that thing just to like make sure that like you're just everyone is keeping up. And then you like have to have a meeting every day after trial being like, what happened today? And make sure you all heard the same thing and like review your notes. Man, this is a pain in the ass for an attorney. I'm feeling for the attorney a little bit now. I'm just saying. It was a slog. It was a slog. I would not want to have to do this. Man, Jesus. Defendants push women to make decisions quickly. Several plaintiffs recalled Jonathan pressuring them to book a flight to San Diego within the first few days, assuring them they could always change the flight or cancel it. Several plaintiffs testified they still had not made up their minds at the time the flight were purchased. Still in their home states, hundreds or thousands of miles away from defendants, some plaintiffs felt they had not made a commitment and still could decide against shooting the video up to the time they boarded the plane. All plaintiffs who flew on the plane relied on the assurances. Yeah, 99 days of trial. 99 days of trial. You figure these lawyers are getting paid $300 an hour. You figure there's more than one lawyer on the case. So figure $1,000 an hour. And you're not just talking about trial time, you're talking about prep time. So figure 10 hours a day. So that's $10,000 a day for 100 days. So that's what, $1 million? Yeah, it's $1 million, conservative estimate for the legal fees. $1 million. Plus cost. Investigators, paper, which is not insubstantial, exhibits, which is not insubstantial, the briefs, the pocket briefs they had to file, the typist time, the clerk's time. Yeah. Ex parte motion was filed. I bet it was. The judge gave him 14 days or something to object, and I'm sure they objected. So, yeah. Upon arriving in San Diego, women are picked up from the airport one by one of the defendants of their employees. So how much do we think the girls are actually going to get? How much are they actually going to get? I mean, half, maybe a little less than half. So the girls are actually probably going to walk away with a collective $6 million if I had to guess. Yeah. That sounds about right. Yeah, something along that nature. Yeah. So, I don't know. Upon arriving in San Diego, women are picked up from the airport by one or more defendants of the employees, such as the videographer or the makeup artist. Defendants and their employees are friendly and make women feel comfortable. Sometimes they go straight to the hotel to check the women in. Other times they make the women go shopping out or eat. Sometimes they go to one of the defendants' apartments to socialize before they shoot. Many women continue to ask questions to confirm what they were told over the phone. They receive the same assurances, often from a different person. Other women were all fully convinced by defendant's representation and did not need to ask further questions. Defendant employees knew how to answer questions about distribution. They confirmed it would not be online. They should never mention the website, and they should reassure the models everything will be fine. The court finds that Pratt, Wolf, and Garcia all knowingly gave false information to multiple plaintiffs in San Diego. Guy and Yusuf also participated in the scheme by misrepresenting or concealing facts as instructed by defendants. The shots take place in a hotel room in San Diego, either that day or the following day. In a hotel room, the videographer sets up lights and camera. The model's hair and makeup are done by a professional makeup artist. Some women report a pleasant, relaxed atmosphere in this hotel prior to shoot. Typically, everyone's engaged in small talk. If the model asks further questions, defendants continue to answer with the same responses. More often than not, Garcia offers alcohol and or marijuana to the model, regardless of her age, before the shoot and encourages her to drink and smoke in order to calm nerves and loosen up. Approximately half of the plaintiffs accepted the offer, and 6 plaintiffs report feeling significantly intoxicated prior to the shoot. Yeah, Pratt et al. Have been indicted by a grand jury. Yeah, I knew that criminal case was ongoing. And it doesn't surprise me, in particular, that the U.S. attorney, which I'm presuming this is the U.S. attorney, it doesn't particularly surprise me. The U.S. attorney was waiting for this case to be finished before they submitted it. They already had it ready to go. All they needed to know was when the case was over. And this case went up, and they went right to court and filed the indictment. Yeah, doesn't surprise me. Does not surprise me. There's strictly speaking no rule that requires that, but maybe they're doing it as a courtesy. Maybe they're waiting to see if anything developed. Maybe they didn't want to prejudice the case, whatever. But I tell you what, as soon as that decision dropped, bam, right to court. Of 28 models who were testified, defendants offered alcohol or marijuana to 7 who were underage. This included McKay, who was 19 years old. Only Jane Doe 4 and 16 claim they were so thoroughly intoxicated they cannot recall portions of the evening. Both showed intoxication in their videos. If only we knew what videos were, we could judge for ourselves, right? YouTube would love that. Jane Doe's 1, 8, 15, 17, 18 testified they felt a moderate symptom of intoxication. For most of the plaintiffs, the alcohol or marijuana served to diminish their defenses and make them less alert. Swarley says, why wait? I don't know. I don't know. As a courtesy, maybe. They didn't want to interfere. Didn't want to interfere with the trial. They didn't want to interfere with it. Maybe just as a courtesy. Or maybe they were still collecting evidence. Maybe they wanted to. I don't know. There's a lot of tactical reasons. If I had to guess, as a courtesy, that'd be my thought. Defendants who are aware the women who agreed to shoot a pornographic video based on the promise it will not be published online will be very upset defendants posted the video. In preparation, defendants had plenty of signed documents just before the filming had occurred. Them waiting doesn't make it so they can use any statements in court in the criminal case. That too, anything under oath could absolutely be used against them, sure. And statements they can be relied on as part of their prima facie case, sure. So any statements from defendants in particular you could use against them. A finding of guilt in a criminal trial is more useful in the civil trial, not the other way around, though, because the different burdens of proof. So it's not like because they're found liable, therefore they're more guilty. But it's helpful. It's just it's a courtesy. Not to contaminate the jury, also possible. There was no jury in this case, though, as far as I understand. It was just a judge. So I don't think it was about a jury. Because as far as I understand, there was no jury. I think it was just a courtesy. It had to be timed, right? What's the odds that they just so happened to file the same day or the next day, then the thing dropped, versus it was a courtesy? So my presumption is courtesy rather than it just happened to be. It could be coincidental, but that's what I'm guessing. Just before filming, defendants presented women with at least one document to sign. Defendant did not provide the documents to the model before she arrived at the shoot, even if she asked whether there were any papers to sign. That is a little scummy, and purposely waited until minutes before the shoot begins to inform the model she's expected to sign documents immediately so filming can begin. That is pretty scummy. Jane Doe 5 emailed Garcia asking if there any contract involved, which was ignored. She just testified she didn't know she'd be handed documents until right before filming. The delay is not for lack of opportunity. Many women testified they spent hours with defendants and their employees, eating, driving around, shopping, or socializing in a hotel room or one defendant's apartment prior to defendants presenting documents for them to sign. By the time defendants are presented, many women have consumed alcohol or marijuana at defendant's behest. Defendant urged them to do so in order to relax, lower their inhibitions, and enable them to go through with the shoot. Although defendants testified to the contrary, the credible evidence at trial indicates they do not permit women much uninterrupted time to read or review documents before signing them. Defendants consistently discouraged the models from reading and rushed or distracted them while they're completing the documents. Some women testified Garcia, Wolf, and or Pratt became irritable and aggressive when they asked questions about the document or requested time to read them. Others testified they were badgered to sign hastily, did not feel they had the option of asking for more time. That's pretty scummy. That's pretty scummy. The court finds defendants used these tactics to reduce the likelihood that women would read and understand what they're signing. Yeah, that is pretty damn scummy. If you don't give them an opportunity to read the contract, that's a problem for you. When handling the document to a model, the defendant briefly explained the purpose and content. The representations are false and designed to induce the women to sign without further questioning. In some instances, defendants actually tell the model documents state the video will not be released online or in the United States and her time, name, and privacy will be fully protected. Sometimes defendants represent the documents or just to prove she's 18 or to show defendants were not forcing her to do this. In other instances, defendants are vague, saying this is just basic agreements, everything we said about, or just kind of a formality. That makes the lawyer heart in me very squeamish. Like, that's not good. Defendants know these representations about documents are false. They're designed to build on and reinforce defendants' prior statements and promises the videos would not be released online, would be only DVDs, or would never be seen by anyone in America. The court finds these representations are deliberate efforts to deceive models about the content and purposes in order to induce the women to sign. By presenting the documents as consonant with and merely memorializing previous conversations and agreements, defendants also seek to prevent models from recognizing these are critical legal documents by which they will be purporting to give up their rights for the first time. These false representations are effective because even if read carefully, the documents themselves do not directly contradict defendants' specific express promises about how the videos will be used. They do not clearly indicate the videos will be published online, as well as dozens of free sites and marketed broadly online. Instead, the documents contain broad, vague releases couched in disorganized, complicated legalese. In essence, upon being presented the documents, defendants profess to be cutting through dense legal language and explaining its purported practical import and effect. It means only the defendants will sell the DVDs to overseas clients, as they've repeatedly stated and agreed. That would qualify most decidedly as fraud in the inducement. Yeah. The articles in release, and Jan points out that this is also creeping up disturbingly on fraud in fact. So, like, I'm not saying a prosecutor couldn't go after it. Like, you could try to make the case for fraud in fact, but like, I don't know that you can even make the case for fraud in fact, because you knew you were going to, because you knew factually you were having sex with this particular guy. So, like, you knew that, and that wasn't fraudulent. So there's no fraud in the fact of it. So, like, they didn't, substitute someone or bring in someone. That would be fraud in fact. But, yeah, you could try to make a case for it. I don't think it will work, but you could try. The artist's agreement and release is a document containing model's name, date of birth, driver's license, or passport information. Federal law requires both model and producer. So this goes to Andy's question about the 2257 declaration. This goes to Andy's question. This is for you. The artist agreement and release 2257 declaration is a document containing model's name, date of birth, driver's license, or passport. Federal law requires both the model and producer to sign under penalty of perjury after the producer examines the picture identification to ensure the model is over the age of 18. All plaintiffs sign the documentation. On the reverse side is the model talent release, a one-page document containing 7 paragraphs of small font. That's not great. With no portions highlighted or set off from the rest of the way to signal importance. The very first document contains 140 words of prolix legalese. I don't know what prolix means. What does that mean? That's a new word for Blackleaf. What is prolix? Using or containing too many words, tedious or lengthy. Okay, lengthy. Noted. For and in consideration of my engagement as a model by Clockwork Productions on behalf of BLL Media, hereafter referred to as photographer, on terms or fee hereafter stated, I hereby give photographer, his legal representatives and assignees, those for whom the photographer is acting, and those acting with his permission or his employees, the right and permission to copyright and or use, reuse, and or publish or republish videos, films, photographs, pictures, or portraits of me, or in which I may be distorted in character or form, or in conjunction with my own fictitious name, or in reproduction thereof in color or black and white, made through any media by any photographer at his studio or elsewhere for any purposes, including the right to sub-license such rights, including any material in conjunction therewith. Well, this is not like that far off from a typical photo video release. The fact they're given no time to understand it, and it's a little bit densely packed, but it's not that far off a typical release. I've seen quite a few of these things, so yeah. The sentence is a grammatical labyrinth which misspells both names and expressly grants many rights the defendants have never used or even considered using. Well, that's fair, but most of these things are written to give the people all the rights. Whether they would ever use them or contemplate using them is not the point. They just want as much release as possible to cover their legal ass. So, the fact that the defendant wasn't going to use them doesn't matter. For example, the sentence specifically covers photographs, pictures, or portraits, reproduction in black and white, and printed material. It does not, however, mention this website, nor the words internet, online, or website. It is thus designed to obscure what will actually be done to the video. That's a fair point. I agree with the court there. You provide some specifics, but not the specifics that were like most material. So that is a fair point. I will give the court that. I agree with the court. Paragraph 3 contains another sentence defendants rely on to support their claim that models consent to online distribution. You and your subsidiaries, successors, licensees, and assignees may copyright, use and reuse, publish, distribute, edit, excerpt, exhibit, and otherwise exploit my name, real or fictitious, or any other name provided and created by Clockwork Productions on behalf of BLLC Media, likeness, performance, voice, pictures, and statements, including those me, nude or semi-nude, collectively my appearance, for any and all uses, in whole or part, any and all media matters, for the program or other program throughout the world in perpetuity without limitations, including in connection with advertising, exploitation, and publishing of the program or public program or any other program. I also want to take note here, just for the, to point out my own self-awareness, just so I don't seem completely self-unaware that I am a lawyer. I have been a lawyer for 12 years. Yeah. And so, for me reading this language, it's like, okay, I read it, I understand it, because it's not my first rodeo. I've read this language before. But for an 18-year-old who has never read this language, it's a little dense. And it's not presenting like the most material things. And it's not like presenting the most material things. So I, as a lawyer, understand, I'm granting the rights for them to give all the things forever. But, to an 18-year-old, although they're legally competent, yeah, it's a little dense. Yes. Especially given what we're doing. I'd want more as their lawyer. This is not helping. And the fact they had no time to read it is not also helping either. So being asked, after taking alcohol, marijuana, being asked to read very quickly this language. I can do it. I can do it very quickly under the influence. Not so sure about the 18-year-old. So just so that we all are aware, I'm well aware that I am not, this 18-year-old girl. So there's that. Yeah. Defendants point to the phrase in any all media throughout the world in perpetuity to show the plaintiffs should have known the video would be published, but rather than conveying useful information, the model of sins merely obscures the true nature and character of the video that will be distributed. Finally, defendants argue the text of the model release precludes the claims now being before the court. I hereby release and discharge you and your successors, licensees, and assignees from any all claims, demands, or causes of actions I may have, whether for libel, violation of my right of privacy or publicity, or any other matter rising in or connection with this appearance or exercise the rights. Well, here's the thing, guys. If it's fraud in the inducement, the contract is not valid. Therefore, your clause is not valid. So, yes, fraud in the inducement means the contract doesn't exist. This clause doesn't exist. So, good times. Yeah. Is it inherently coercive if it may decide after becoming intoxicated? I don't know if it's inherently coercive, but it definitely isn't helping. Especially when you're the one who gave them the intoxicant. That's also not helping. These are facts that I would prefer not to have as the lawyer for this website. These are not helpful facts. Yeah. I would not encourage giving drugs to someone under the age of 21 and alcohol and not letting them read it and not having the most prominent clauses noted and, so forth and so on. There are many here. There are many issues here I, as their lawyer, would have problems with. So yeah. Many models also signed a second document called a model talent release, an independent contractor agreement. Ooh, there are several iterations of the document, but most plaintiffs cite a version that on the first page contains recitals. Recitals are usually interesting, but not particularly legally significant. What if you get their lawyer hired when they come to review it? Also, probably not helpful. No, that's not good either. Whereas BMI has undertaken the design and development of adult-oriented content, and whereas videographers, videos, photographs, and other media includes nude and semi-nude images that may comprise a significant portion, and whereas the models voluntarily are willing to create exclusive video and or photographic content for BMI under a work-made-for-hire arrangement, as the term is defined by United States copyright law, and whereas models understand that BMI shall own all worldwide intellectual property rights, copyright, trademarks, services, mark, patents. How you're getting patents out of this, I don't know, but as their lawyer, don't object to this clause. I throw that in there, sure, why not? I don't know how it's relevant, but again, I want the broadest release possible. So sure, let's throw patents in, that makes sense. In any of all videos taken of the model and any or all content created for BMI and other purposes. Now, therefore, in consideration of the foregoing and mutual promises contained herein, and for other good and valuable consideration, the receipt and adequacy of hereby knowledge is agreed as follows. The independent contractor agreement goes on to list 21 numbered and detailed terms, some of which contain several subparts, covering 8 pages in all. It's not until the bottom of the second page in paragraph 7, entitled Model Representations and Warranties, the document refers to the internet, stating, Model represents and warrants that she is not modeled for any other website, agrees not to model for any other online website or other form of adult publication. Model acknowledges BMI shall have exclusive rights to model's likeness for online purposes or other purposes. The defendants argue models can deduce from these two sentences that BMI runs a website, not encouraging. But defendants have repeatedly professed otherwise and bury this disclosure in a lengthy legalese document that models are not permitted to read and digest. The import of this section is the restriction of models' outside activities, not a representation regarding defendants' use of videos. The court accordingly finds the independent contractor agreement also fails to adequately disclose defendants' website and pre-designed intention to publish the videos online. Yeah. Immediately before filming, defendants hand women a sheet of paper and instruct them to read it for the camera. Women rarely have a moment to skim the script before the camera's rolling. The script says, I, real name, am doing the scene for BLL Media of my own free will and of sound mind and body. I'm not under the influence of any drug or mind-altering substance. I know the picture and filming today will be used in scene. After the scene is filmed, I know I have released all rights whatsoever to footage. Anything contained in the footage may be used by however BLL chooses. All other model agreements stay in the model release. I willingly sign to do this scene. Some women read without comprehending, think little of it, and do not ask questions. Some women do ask questions, at which point the defendant simply continues to misrepresent, giving a flippant explanation so that we know that you're sober. For testing the sound and levels on the camera. Oh, that's a good one. For giving us permission to film you, or even to cover our butts. Well, that I don't necessarily object to. I object to many other parts of this, but the explanation to cover our butts is not the worst explanation. For testing sound levels makes the lawyer in me cringe, though. That's not good. Some women are confused by the script because they are saying they're not under the influence of alcohol, but they just consumed alcohol prior to them and provided by defendants. The women conclude, quite understandably, the script is of little import. Everyone in the room knew I wasn't a sound mind because we had just smoked. Nice. I love how you guys are now arguing about font sizes in the chat. So that's encouraging. Please continue your discussion of font sizes. And also, I'd like to note that Garamond is the best font, and anyone who disagrees is wrong. How about that? Most plaintiffs terrified the script did not raise any red flags. For those who testified that they did not find the script puzzling or concerning, they also testified defense explanation and continued assurances assuaged their doubts and put their mind at ease. The court finds that misrepresentations, the purpose and meanings of the script, defendants had continued to conceal the facts about the video's intended online destination, including the names of the website on which it would appear. Prior to the sexual portion of the video, defendants place the women on the bed to conduct an interview to personalize it for the audience. Defendants do not tell women about the interview prior to the travel. The interview consists of defendants asking the women personal questions about their histories and preferences. Defendants instruct models to act flirty and perky, and often give them scripted lines to respond to certain questions. Nearly every woman says she's excited to shoot but nervous when asked how she's feeling. If defendants do not like a woman's answer to a particular question, they stop filming, coach her on what to say, and reshoot the scene. Good. Some women are quite uncomfortable answering truthfully, so they make up answers. Other women just go ahead and answer highly personal questions they believe no one in the United States will ever see the video. Several plaintiffs testify they would not have agreed to the interview or many questions if they known they planned to post it on the internet. After trial, defendants used these interviews as evidence to rebut some plaintiffs' claims they were not frightened or wanted to leave but could have done so. However, a video acting outwardly happy and flirty in a stage interview is not persuasive evidence of the woman's actual state of mind. Defendants manipulated the interviews by coaching the women on what to say and how to say it and carefully editing. Women need to comply if they were to be paid. It's not disputed some plaintiffs were fully taken in by the ruse, were not frightened, and were quite comfortable with the experience as a whole. Videos of these women cheerfully answering questions she believes no one will ever see do not undermine the fraud claim and in fact shows how thoroughly they believe the defendants. After the interview, the sexual portion begins. Based on a stipulation among the parties, the court will not address this portion of the shoot. Okay. Except to note, it takes much longer than the advertised 30 minutes, also several times as long. I'd be interested to know about this stipulation. I mean, it's in the record, right? So the stipulation's in the record. I'd be interested to know more about the stipulation. That's interesting. Moreover, the woman's entire body, I mean, technically it's, well, maybe, is it relevant or not? I mean, it's kind of irrelevant because now we're actually ongoing. So it's irrelevant to fraud in the inducement. So, I mean, there's that. So maybe we're stipulating it for that reason. It's irrelevant to fraud in the inducement. Probably. The woman's entire body, including her face, is fully visible to the viewer throughout, while the male actor's face is never in frame. Andre Garcia was the male actor in all the videos. Defendants present no evidence they forward plays if only her face and not Garcia's would be in the frame. Further, the court does not consider the testimony of several plaintiffs that at some point during the shoot they asked to stop, but plaintiffs would not permit them to leave until they had the footage they wanted. Well, now you're getting a lot closer to a potential rape claim, right? If someone says, I want to stop, and you don't allow them to stop, you're a lot closer to a rape claim, because now you don't have consent. So there's that. Just saying. If you were looking for rape, that's a lot closer. Ooh. Ooh, that's a lot closer. Oof. Ooh, that's not good. The fact is important because defendants arguably repeatedly that plaintiffs chose to be in San Diego, chose to sign the documents, and chose to go through with the shoot. Defendants' argument ignores the obvious implicit power dynamic invariably present in the room. The women are alone in a hotel room with two men they barely know, who, although friendly at first, become aggressive and agitated if the woman expresses hesitation or desire to leave. Several plaintiffs testified they had second thoughts but felt they were not in a position to leave. I'm not sure I really agree with that sentiment from the court. The law treats everyone as equal, so I have a little bit of a hard time saying it's power dynamic. It's not like teacher-student, it's not like that kind of power dynamic. It's not like a position of traditional like authority where you wear that. So I'm a little bit hesitant myself to say, well, there's a power dynamic problem. There's a lot of other problems, as I point out, but I'm not sure I agree with that paragraph. Not that it really matters to the conclusion, but whatever. Plaintiffs were also acutely aware of the risk of leaving the shoot. First, defendants held and controlled the plane tickets, and most plaintiffs could not afford to purchase a ticket home. That's not good. Secondly, aware defense had new pictures, in some case video, plaintiffs did not want to do anything rocking the boat for fear defendants might retaliate. That's fair. Further, many women did not want to know what they were doing and therefore had not told anyone and didn't want to call anyone for help. Yeah, that's a fair point. Yeah. Too drunk to give consent is definitely a possibility in contract. Yeah, too drunk to give consent is definitely a possibility as well. So we would have lack of consent as additional argument. Not that we need it, we have fraud and inducement, but yeah, lack of consent. If you're so high or so intoxicated, yeah, that could be a problem. And some women said they blacked out, so presumably they would fall into that category. After the shoot involving the intercourse, defendant asked women to film a solo video. Defendants tell women the solo video be distributed in the same manner. All plaintiffs who shot more than one video did so before their first video was published online. Plaintiffs had no way to discover defendants had lied to them. That some women shot more than one video does not mean they were defrauded. What? To the contrary, it's consistent with their testimony they were deceived into filming the videos. I don't understand the court's sentence there. Is it possible to turn off message holding? I don't know. Presumably, there's a way to do it but the messages that are held are presumed to be a problem. But I don't know if I can do it on the fly. Let's see if I can do it on the fly. See, use blocked links, default settings, allow all comments. Okay, I can disable this check mark. I can disable that check mark. So that will maybe work. So if that works, then there you go. Hopefully that will be helpful. Defendants never sold the videos on DVD format. Contrary to many representations, defendants published plaintiffs' videos on the internet. On top of this, defendant used aggressive marketing strategy to encourage as many people as possible to view their videos. Defendants published the boy-girl videos and the solo videos. The full-length videos are published only in the members area of the defendant's subscription websites. These can only be accessed by purchasing a subscription. However, defendants also posted still images from shoots and short clips. Videos and image of each plaintiff appeared on publicly available homepage. Once a video is posted on the subscription website, defendants embark on an aggressive advertising campaign to maximize the number of people who learn or see about the video, the website, and purchase a subscription. This effort includes making clips of the videos available on popular free tube sites, affiliate marketing, and ensuring people who know the female model will learn about the video, piquing curiosity and making it go viral. In order to advertise the sites, defendant posts clips of videos, including plaintiff's video, on the free tube sites, which are heavily published and popular and trafficked. Thank you, Big C Burger, for the $10 super chat. I have nothing to say, just supporting you financially. Well, thank you, Big C Burger. I really do appreciate it. As you might imagine, for reasons one can only begin to speculate about, YouTube demonetized this video. I don't know why. And so, I would appreciate it if you give this a super chat, I would appreciate it because it shows that I should do stories like this, right? I should do this because I'm getting validation back and you're showing me that you want this. If I don't get money, it shows me you don't want it. I'll stop reading. No. Thank you anyways. I appreciate you guys being here. That really is a reward too. I also like how I have 39 concurrent viewers. That's just amazing. So thank you. Thank you to the 39 of you who are watching this. In order to advertise the subscription sites, defendants posted clips including on free tabs, the free sites. Okay, free sites are popular. Defendant's channel receives enormous amount of traffic. The channel on Pornhub is a popular channel with more than 700,000 subscribers and more than 600 million views. All or nearly all the plaintiff's videos were at some point available for free on the channel. According to the view counter, plaintiff's videos have been viewed anywhere from 200,000 times to 35 million times. Well, presumably, I could use that data to figure out at least who one of these people is, right? I could sort by their view count and figure out who is that 35 million person. So at least one Jane Doe I can expose thanks to the court's precision. That's great. Walnuts. Walnuts are good for energy. And they're good for keto. They're very, very keto friendly. Jan, it's easy to find names. I don't know if it's easy to find the names for these people in particular. That's the question. So it's easy to find names for them, but I don't know if it's easy to find the names for these people. If you think it's easy to find the name for these people, let me know. Each plaintiff has proved after her videos were placed online, they spread throughout her circles, including family, friends, coworkers, employments, teachers, and classmates. As a result, most plaintiffs experience merciless harassment. The court finds defendants knew at the time they recruited each and every plaintiff that the result was inevitable. The court further finds defendants deliberately proffered from the videos being leaked to plaintiffs' personal circles and community. At best, defendants knowingly stood while this happened in order to increase traffic. At worst, they encouraged and facilitated this outing process and even participated directly. The spread of videos throughout social circles did not happen by chance. It is the foreordained outcome of a deliberate campaign by online trolls. Nice. Oh, they're giving me episode numbers? Oh man. Oh my god. Well, that's great. That narrows it way down. Stemming from a perverse fascination with, and perhaps disdain for, women who appear in these videos, anonymous internet users congregate on online forums such as pornwikileaks.com. Episode, yeah. And 8chan. Oh, they're referring to exhibit numbers, not episode numbers. All right, never mind. The trolls share information they find, including Miles' name, biography, links to social media accounts, and other contact information on the forum, and harassment begins. Armed with the woman's social media and contact information, some trolls spend their time sending links to her video to people connected to her on social media. Other trolls contact the model personally to attack, bully, and shame them, or to comment on the video and proposition them. Jake the Hammer gives me 20... I forget what SE key is. Isn't it like... I want to say Ukrainian or something? I'm down for more lascivious stories. Yeah. And the video may be part of the exhibit. I have no doubt believing the video is part of the exhibit. Yeah. Defendants admit they're aware of such lists for years. In fact, defendants have sought something of a cult following on the forums. Numerous websites and forums exist for the sole purpose and outing of doxing the models. An Instagram account called Girls Do Porn Real Name. Practice discussing real ideas, maybe girls do porn or something. Dog Blog Spot. At one point, Porn WikiLeaks hosted a forum called GDP Exposed Real Names and Personal Family Info. Swedish krona. Thank you for the 20 Swedish krona. I'm down for more lascivious stories. You're welcome, Jake the Hammer. I'm happy to provide the stories that I find interesting and that are lascivious. So good times. I'm hoping, yeah, the fact that I'm demonetized means I'm probably not showing up in YouTube search, I would imagine, Matthew says, I'm just saying, if we get the exhibits, I'm saying there's a non-zero chance you'll never see uncivil law on the internet ever again. But why would that be, Matt? Why would that be? We're just merely discussing law. And, to discuss the exhibits is to be able to fully appreciate the legal issues that are at bar, right? So, we would be less than complete if we didn't discuss the exhibits. Why would YouTube object? The court notes plaintiff need not show defendants personally leaked the names or participate in the harassment, although there's evidence that they did. Nice. It's enough that defendants knew they would be leaked, so the videos would be sent to many of the people they knew and they'd be harassed. Yeah. The court has little doubt that the defendant's actual knowledge of the eventualities. Dozens of prior models complained to the defendant about their names being leaked in with the videos and being harassed. The earliest record is dated July 1st, 2013. Pratt was certainly aware of the website when he purchased the domain. He purchased the domain called pornwikileaks.org. Nice. Yeah. Despite this knowledge, defendants never informed prospective models of the doxing list and campaigns of harassment. In fact, defendants' business model depended on convincing models that these consequences, well known to defendants, were not within the realm of possibility. Defendant therefore continued to include the same misrepresentations in the initial recruitment email. Defendants immediately benefited from the doxing. Publication and dissemination of models' names and personal information increased views and traffic. Nice. Porn WikiLeaks forum dedicated to revealing these names. The banner published on the site owned by defendants provided them a straightforward and plausible explanation of how the information was routinely made available. At a minimum, defendants knowingly permitted the banner to remain, encouraging members of the forum to continue their activities and attribute them to defendants. Nice. Well, it's nice to know you're from the good old USA. So am I, man. And I also use a VPN. At the moment, I'm using private internet access. GDP model names were released in a manner strongly suggests Pratt was involved. Multiple models were outed on the forum the same day, with posts including names, pictures, social media accounts, email addresses, and other personal information. It's in the exhibits. So all we need is the exhibits, man, which are probably under seal. But yeah. Defendant recognized the traffic and notoriety the websites received on the forum and sought to maximize the benefits they received. Defendants claim Pratt purchased the site so he could take down the names of the models. However, the internet archival data for the website belies this personal explanation. Should we go to archive.org and look it up? After the transfer, the doxing pages were actively maintained for 7 months until the day the lawsuit was filed. Yeah. All this evidence points to the conclusion that Pratt owned and controlled the WikiLeaks for at least 7 months prior to the time he could have been removed. Yeah. Apparently, that was worth about $2 US. Since I can see it in US dollars in the chat revenue. So thanks for the $2. And Jan gives me $30 or 30 PLN. Here's financial help. I didn't have the money before today. These guys are disgusting, by the way. Thank you. I agree. That's worth about $8 US according to YouTube. Thank you for your donation. These guys are pretty disgusting. Their behavior is pretty reprehensible. I think we can agree on that much. All this evidence points to the conclusion Pratt owned and controlled the website for 7 months. One particular piece of information confirms the likelihood, if not reasonable certainty. I can buy the exhibits on the website. Man. The name and episode of MF, a third-party model who testified by deposition, was posted on the forum. The deposition was posted. That's cool. I mean, it's cool to me as a lawyer because I like reading them. It's not cool that she was exposed. That's what I mean, just for the record. The post also includes 1 semi-nude and 3 nude photographs. Testify that she took pictures in her college dorm room at Pratt's request and then sent Pratt and no one else. Defendant's website ownership is not isolated. In summary, the court finds defendants not only disseminated videos, but went a step further to widely publish the identities as it suited their interests. How are we doing? Page 39. So we're roughly 20% of the way through at an hour 48. I'm not sure how much longer I have in me, guys. It's hurting my voice talking this much. I saw Rakita Law. Rakita Law apparently has done 24-hour law streams. I don't know how that's possible. I don't know how it's possible to keep talking for 24 hours. I've seen gamers do it. They're not talking the entire time, but I've seen gamers do 24-hour streams. I don't know how it's possible. The court is profiting. Yes, it is. And I thought Pacer was bad because Pacer charges, was it 15 cents a website page? These guys are charging 50 cents a page. The federal government's only cheating me to the tune of 15 cents a page. These guys are cheating me 50 cents a page. State of California. Lord. 102 pages, $13.49, 94. I thought it was more than that. Because when I saw it, I thought it was 50 cents a page. Jesus Christ. When models eventually learn and publish online available in the United States, they often complain. Of the 22 plaintiffs, 12 presented documentary evidence they attempted to contact. Several plaintiffs testified they attempted to contact but did not have a written record. When defendants received these complaints and requests, they responded to a number of ways. Several plaintiffs testified they were ignored. According to testimony, Pratt, Wolf, and Garcia actually instructed their employees to block the phone numbers as soon as the shoot was done. Very nice. Jan says there's a 24-hour recently on Hello Future Me playing and talking simultaneously. Please ask Hello Future B why it costs so much. Why do PDFs cost anything? Because the government wants revenue. Reference models Caitlin Wright testified defense told her if any of the models called, she'd block the phone number and not respond. If defense did respond to the complaint personally, they often did so in a threatening manner. For example, when Taylor Rogers learned her videos were online, she texted both Pratt and Garcia accusing them of lying. Pratt responded by saying, "You don't know what we're capable of. We have your social security number." Outstanding. That's good stuff. Oof. He threatened to report her to the IRS and take other unspecified actions. Well, what reporting you to the IRS is like not a deal. The IRS can't do anything to you if you're paying your taxes. And she had an obligation to pay her taxes. So, you have to pay tax on its income. I wonder if they gave her like a 1099 or something as an independent contractor. But yeah, she has to pay taxes. So anyone who wants to report me to the IRS, for example, go nuts. Report me to the IRS. The IRS can't touch me because I actually pay my taxes. I don't care. In some instances, defendant appeared to be willing to help the women solve their problem of public discourse, but never actually took action. In other cases, defendant referred their complaints to Panko's Law, which sent the women cease and desist letters and threatened legal action. Ooh. Yeah. Defendants also threatened legal action if prior models attempted to tell her story as a warning to others. Dispatched a cease and desist letter that contained semi-nude pictures of Jane Doe. Oh man, wow. Well, that's lawyering sending a cease and desist with images, man. Jesus. Whenever a model contacts a website to attempt to remove a video, defendants respond by sending signed documents and asserting the model is making a false claim. However, when models request a copy, defendants ignore it or refuse to honor it. An audit for me probably would not be that annoying because I have one income source. It will be a very, very short audit, and I claim the standard deduction. I don't itemize my deductions. So an audit of me, what would they be auditing? It's like I have one source of income, and and I have some bank accounts which produce some interest which I disclosed, and I don't itemize my deductions. So what are we auditing? There's nothing to audit, So it'd be a very, very short audit, I would imagine. So sure, audit me. Go nuts. It's a very easy thing to do. Pratt established shortly before the lawsuit, the website generated $2.5 million a year, and the toy site generated $18,000 a year. Your dark money from YouTube. I am going to report the dark money from YouTube on my income. Now that will be interesting because I think I can claim it as hobby rather than regular income, and I'm not sure how that affects my taxes, but I will figure it out once I get my reports from YouTube in terms of reporting it to the IRS. And I will happily pay them any amount of tax that they are due. The court finds that Domini was not forthcoming in providing financial information during discovery, so the revenue and value of the Domini cannot be established. However, Pratt establishes he received a salary of approximately $4,000 per week or $19,000 to $20,000 per month from Domini. The parties stipulate defendants received a total of $1 million in profits from the use of the videos. Okay. The parties stipulate defendants received $1,025,831.50 in profits from the videos. Thus, it is undisputed defendants derived $46,628.70 from the use of each video. Okay. Doesn't quite follow that's even, but I'll let the court do what it wants. Plaintiff's financial expert Robert Taylor offered opinions on the two matters. First, he was asked to project the economic benefit of Pratt's library on the unpublished videos. He testified he estimated a present value of economic benefit that will ensure to Mr. Pratt, from what I've been informed, his library of excess of 200 previously unloaded videos to be $4,672,194. Yeah. Yeah. I will figure out the tax issue on the hobby income. And if I have to report it as regular income, I'll report it as regular income. So, I don't know, but I've only heard a rumor about the hobby thing. I'll look into it. I'll report it, and if I get it wrong, the IRS will tell me, and I'll pay the corrected amount. It's like, well, I should have paid you this amount instead of this amount. Okay. Taylor was asked to estimate the net worth of the entire enterprise. In his opinion, performing the analysis wouldn't be accurate or precise as if he had information. Let's see. To do so, Taylor started with a projected income. And according to Pratt's bankruptcy schedule, his home netted $507,000. His car netted $93,000. The sum of these amounts is $6,487,000. So he had a $93,000 car. Good for him. I'm imagining some kind of Porsche. Just speculating because it would go in with the firm. Yeah. Based on the evidence, court accepted Taylor's analysis and find defendants non-pornographic enterprises worth $6,487,000. Lord. Shortly after Jane Doe retained counsel in an effort to obtain documents she signed, court finds defendant level significant harassment. You shouldn't do that. Jane Doe's video was suddenly and immediately sent to dozens of students, professors, and administrators at her law school. Ooh. Oof. Oh, man. Oh, that's horrible. That's bad. While defendants deny they had anything to do with harassment, yeah, right, record indicates it's more likely than not they're behind the harassment. Shortly after they contacted defendants, an article appeared on a popular gossip website with focus on the fact that she was a law student and meticulously impugned her character and intelligence. This article contains one telltale detail suggesting defendants are behind it: the unfounded accusation Jane Doe escorts in Vegas over the summer. Jane Doe testified that something Garcia asked her to say during the interview, but she refused to and said she was a hotel receptionist. She said no one else had ever accused her of such a thing and believed the comment in the article could only come from Garcia or Wolf. Yeah. The court finds Pratt, disguised as Taylor Ann Fairchild, personally took action to spread the video to important people in her life, including her employer, her college soccer coach, and her sister. Woof. Thus, the same Ann Fairchild account also contacted Jane Doe's mother, revealing the video. Oh my God, that's so scummy. It makes me laugh, man. Jesus. Wow. These people are not nice people, man. Two witnesses testified defendants or some other one on their behalf and offered them money or refused to speak with counsel or engage plaintiff's counsel to learn information from defendants. After a lawsuit was filed, defendants, through an employee, Kevin Gibson, offered to pay the reference woman, Alicia McKay, $10,000 in exchange for any information she could provide about the plaintiff's attorney. Why would Alicia McKay have information? And you could just ask fellow lawyers. I mean, they'll tell you information. And you can find stuff about him. It's not hard to research an attorney. No, not particularly. Reference women Embellyn Clark also testified Garcia offered her $1,000 to compensate her for trouble of dealing with this and not to talk to anyone. Daniels often taken highly unethical actions against plaintiff's counsel in either the hopes of intimidating them or simply to punish them. Plaintiff offered numerous articles that have been published online containing outrageous accusations about plaintiff's counsel. The testimony of witness, I'm interested to know what these accusations are just for color, but yeah. The testimony of witness Jamie McDonald strongly suggested Pratt was responsible. Some of the false articles were posted on two websites that Pratt owned or controlled, suggesting he had a hand in publishing them. Lord. Yeah. And in this case, there is no original recap doc. There's no PACER document. Well, there is, but not that will help us because this didn't occur in federal court. This is state court. So PACER is of no use to us in this circumstance. The complaint was filed in federal court. When I did my previous video, I looked at the complaint. We covered that in a previous video, but the actual trial happened in state court. They got sent back. So, yeah. Ms. McDonald testified she was hired by Gibson to call the plaintiffs as many times to pester and subsume their time. She received $300 a week for doing so. Great. Just great. In the face of a website by 22 previous models, and despite referencing women and former employers, defendants have done nothing to change their business practice to solve any problems. Wolf testified that the website is still not disclosed on their documents. The testimony of Jane Doe, I'm not sure who that is because we're doing numbers now. I think the court made a typo there. Made clear Garcia is still using the same recruiting practices. Garcia was still sending the same initial mail. Defendants created a new modeling website, which may not be useful as recruiting tool because it's been discussed by name in this website. That's a nice little burn from the court. It's been discussed by name in this lawsuit. All right. Whew. Having considered the testimony and credibility of each witness as well as the evidence, the court finds the following facts. These are now facts. Yay. In 2015, Jane Doe 1, clerking part-time at a law firm in Nevada, after completing her first year of law school, presumably at the University of Nevada, Las Vegas, was in need of additional money to cover her expenses, so she applied for modeling jobs. After responding to defense ad, she received Jonathan's stock email. They exchanged emails before speaking to him. And where's the footage asked? Over the phone, Jonathan told Jane Doe the video was just for this one guy in Australia on one DVD that could not be copied. He wouldn't know my name or wouldn't know his. It's all going to be confidential. They're going to be like documents that represent this. No one else could see it. It would never be online. My name would never be attached. Jonathan asked her to send him nude photos for approval, which he assured her would be kept completely confidential, so she complied. Jane Doe believed Jonathan because she specifically told him she was in law school and she shared her concerns about confidentiality, saying, I can't have my family or friends knowing about that either. He told her that he had shot models before this collector and never had any issues and no one had ever found out. Jane Doe also spoke with reference model prior to traveling. Right reassurance had a massive impact. Upon arriving, she continued to seek and receive assurances about confidentiality and distribution from both Jonathan and Ben. In the hotel room, Jonathan encouraged Jane Doe to consume alcohol, and she felt the effects of the alcohol by the time she was asked to sign the documents. Ben also distracted her by filming her and asking her questions while attempting to review. She asked for more times to read the documents, but told there were no times. She's a law student, right? So she's already had 4 years of undergrad. She's a law student, so she's a little bit more able to like keep up with this. Just, by way of, so she had probably read language and knew the significance of it to a greater degree. So, I'm just pointing out that, she's not 18. She's presumably 23, 24. And, so there's that. She read the script without asking questions because she believed she knew how video would be used. I wasn't of sound mind. Okay, well, that goes a long way. I wasn't of sound mind. Fine. Jane Doe was convinced by Jonathan continued need to see the approval of the owner by text or phone, by Ben's Australian accent. Australian apparently means authenticity. Yeah. There are people such as this that collect stuff. Okay, well, that's interesting to know. There are people out there who want custom stuff. Okay. Jane Doe learned her videos were online when she received a call from her boyfriend, followed by a link. I bet that was a very interesting call. from the boyfriend. She immediately called Jonathan, then Ben multiple times. A few days later, when she tried again, found the number had been disconnected, she realized they were part of a scheme. She sent an email to an email address, but this time she did receive a response to cease and desist, threatening to seek a restraining order. At that point, Jane Doe retained Mr. O'Brien, who contacted Mr. Saddock, requesting copies of the agreement, which were not produced. Good for her for seeking an attorney. Within days, students, professors, and deans at her law school began receiving calls and emails referencing the video. Approximately 60 emails of this type were sent to her law school. When Jane Doe 1 received a threatening phone call, she began to fear for her safety, so she reached out to her dean for assistance and filed a police report. Jane Doe 1 received a message from someone forwarding her an article about her from thedirty.com, a popular gossip website, which also forwarded to her law school. The attack vigorously attacked Jane Doe 1 and, importantly, contained an accusation she was an escort. This detail led them to believe the article was either from Garcia or Wolf. In or around December 2015, the court finds Pratt, disguised as Anne Fairchild, began reaching out to important people and informing them about the video. He sent her an email disclosing the video to the law firm where she'd been working. Oh, man. And her college soccer coach, as well as her Facebook message to her sister. I'd be surprised if the law firm didn't immediately follow her, just because law firms are very, very conservative, in culture. Jane 1 believes that the communications disclosing the video to her law school employer, former coach, and sister came from defendants. On November 10th, she learned about it from Caitlin Wright. She visited the forum, but she did not see information about herself well until the first emails were sent to her law school in the article. Within days, pictures and links to her social media, law school website, modeling profile, the article on The Dirty, her college website, and her employer were posted. The release of the video has and continues to have a significant impact, perhaps more so because of her chosen career path. As a result of her messages, Jane Doe was previously very active, stopped participating. She struggled to focus on class. She had to have a friend walk her to class because she frequently threw up due to anxiety. Although she completed law school and passed the bar exam, Jane Doe no longer wishes to be an attorney because of the impact a video has had on her reputation. I also wonder, just FYI for my own edification, what the Character and Fitness Committee had to say about any of this, because I'm sure it came up. Jane Doe testified she wanted to be a mother, but now feels she cannot because she would not want to put her child what she was going through. Jane Doe experienced fear and paranoia after receiving the threatening phone call. She has severely anxiety and depression, which has been prescribed multiple medications. She has twice attempted suicide, first by taking a bottle of pills within a month or two after the video appeared online, and second, in 2018, when she attempted to load her boyfriend's pistol, but discharged and accidentally lodged a bullet in the floor. The court finds Jane Doe 1 to be credible. Okay. Well, my friends, I apologize, but I feel my voice is going out. I'm beginning to run my words together and not enunciate. And I've been trying to correct for it as best as I can, and I'm not able to correct for it anymore. I can hear the words coming out of my mouth, and they're slurred and not clear. And I want to be clear. And, so my voice is given out. Thus, as a result, we made it to page 48 of 187. So we will probably resume this at some later time and try to finish the story. I don't know how the streamers who do it for 24 hours and talk do it. I obviously need lessons or something. So if anyone has any tips for how to speak for very, very long periods of time, how to filibuster, for example, I will happily take them because I have reached the limits. My voice is beginning to hurt. So, for the 42 of you who are watching, if you've not already done so, I would very much appreciate it if you gave me a like for this video. And if you have not already done so, I'd appreciate if you gave me a subscription so you can follow more. I'm going to have dinner now. I'm hungry, and my voice is giving out, and we'll probably do more of this at some point. Tomorrow, I have to do my streaming because I'm traveling on Sunday. So I'm doing my normal videos for my normal stream tomorrow, and I won't have my recording equipment for a while, so it will be a while before I get back to this, but I'll try. So, until later, my friends, that is all. I hope you're well. Until later, cheers and goodbye.